We want to take a look at the legal side of this ruling and what it could potentially mean for other landmark cases. Let's bring in our friend, NBC News legal analyst Danny Cevallos for more. So, Danny, first, let's start with Friday's ruling and the potential legal implications here as these trigger laws go into place, as laws that were on the books from pre-Roe come back into play here. What happens for people if they're criminally charged for performing or receiving an abortion? What could their potential case look like in a courtroom?
The answer is anything that particular state's legislature wants it to be. And that brings us really to the next battleground in this debate, which is going to be state extraterritorial jurisdiction, the power of an individual state to criminalize activity that happens off campus. In other words, off the state grounds in an adjacent state or some other state. An example might be a resident of that state who picks up, gets in the car or gets on a bus and drives to a neighboring state in order to obtain an abortion. To what degree can that original state criminalize that activity, even where the abortion doesn't happen within state boundaries? So that is where we're going to see the next battles in this controversy.
I also want to ask you about where we could see this headed with potentially other rights that were granted by the High Court. So Justice Clarence Thomas says he wants the court to revisit and overturn potentially other landmark rulings, ones that legalize same-sex marriage, the right to obtain contraception. And he says, quote, "We have a duty to correct the error established in those precedents." Now, after last week's ruling, I mean, what do you make of that? Does that mean those cases are in jeopardy? Of course, it has to be something that brings it to the court again. But what do you make of reading that in that opinion?
Had you asked me that question last week on Thursday, before this opinion came out, I would have said, Savannah, pshaw. If you read that earlier draft opinion that was leaked, Justice Alito went to great lengths to say, take it easy. Abortion is what we call sui generis in Latin. It just means unique. Abortion is the only right that results in the termination of another life. Abortion is different for many reasons, reliance interests, all these other reasons that make it unique. You need not worry about all of these other bundle of rights that are the unenumerated rights, part of substantive due process that the Warren Court created by expanding on rights that they saw that were kind of in the Ninth Amendment, kind of in the Fourth Amendment, this penumbra, this glowing of rights. That's what I would have said Thursday. And then Clarence Thomas has a single sentence in his concurring opinion that blew up the landscape and totally changed my view, because I have to feel a little bit like Lucy in the Football and Charlie Brown. So many times I even wrote an article, an op-ed about this that I'm going to get bashed over the head about, that said, I don't think we need to worry about Roe v. Wade because so many nominees said, hey, it's settled law. Well, shame on me. Now we have Justice Thomas saying we should revisit it. He's the senior most judge. He's got a lot of influence. So I think folks should be concerned now about all these other bundle of rights that came out of the Warren Court era, Obergefell included, Lawrence v. Texas. All of these rights that aren't explicitly in the Constitution, they may now be up for grabs.
And that was a point that's actually been raised by some lawmakers, that they feel that they heard something different in some of those confirmation hearings than what we actually saw play out. Danny Cevallos, as always, thank you so much. We appreciate your help here.
Thanks for watching our YouTube channel. Follow today's top stories and breaking news by downloading the NBC News app.